In this episode, I discuss alternatives to solving gendered violence that do not involve mass surveillance or incarceration. Efforts for abolition and systemic change have become more mainstream, especially since the pandemic and 2020 BLM protests. Episode 3: Alternative Ways to Stop Gendered Violence. However, this type of abolition talk has largely been avoided in the gendered violence context. For many feminists, it is difficult to articulate gender and sexual violence outside of the criminal justice system. Many of the same advocates calling for defunding the police also support heightened criminalization in the domestic violence realm. In The Feminist War on Crime, law professor Aya Gruber discusses the revolution of the feminist movement as a turn to increased policing and incarceration as a solution to sexual assault and domestic violence. She describes how women's criminal law activism had not made prosecution and punishment more feminist. Instead, it had made feminism more prosecutorial and punitive. In this video, I would like to highlight other avenues for domestic violence justice besides incarceration. As shown in my previous video, for many reasons, DV survivors do not want incarceration to be the answer. Often their lives are intertwined with the abuser, they can be financially dependent, have children with them, have a house, or do not want to disrupt their lives. DV situations are so complex. Each situation can be different and require individualized help that the carceral system cannot provide. Also, many well-intentioned lawyers can take away the power of the survivor by dictating their choice when prosecution charges are involved. In her book, Professor Gruber described a situation when she was a junior public defender of a client, Jamal, age 19, who was arrested after his girlfriend, Brittany, age 18, reported that he punched her and threw a plate at her. Jamal and Brittany lived together with their baby, and at trial, Brittany told Gruber how she did not want to be there, how she was mad and wanted Jamal out of the house, which is why she called the police, but did not want him arrested. Brittany did not want to pursue charges and affirmatively said she would not comply with the no-contact order. The prosecution moved forward with the case after Brittany insisted not to, and did not show up for trial. Jamal pled guilty and served time in prison, leaving Brittany struggling to pay for the apartment and baby by herself. And after Jamal was released, they lost their eligibility for public housing because of his conviction. The well-intentioned feminist lawyer, in an effort to seek justice, took away any power Brittany had, and she ended up worse off because of the incarceration. While this story is merely anecdotal, it shows the problems that can come up when incarceration is the only answer. Instead, I want to move the conversation away from incarceration and towards other, more productive ways to help. Citing Blacklaw's dictionary, distributive justice refers to justice owed by a community to its members, including the fair allocation of common advantages and sharing of common burdens. Its purpose is to have society take responsibility for making the victim whole again, by providing emergency financial assistance as well as other public resources. With financial restraints being cited as the biggest barrier to leaving an abuser, distributive justice can be used to help alleviate this. This can include emergency financial assistance, medical care, legal services, and transitional as well as supportive housing, which is especially important given that more than 63% of homeless women have been victims of domestic or sexual violence. To help with the assistance to victims, Congress enacted the Victims of Crime Act of 1984, or VOCA, to address some of the needs of victims of violent crime. VOCA provides federal funding to eligible state crime victim compensation, or CVC programs, which directly reimburse victims for crime-related expenses and are sponsored by the federal and state governments. When CVC was first enacted, there was bias against helping DV survivors, as the funding could be given to the abuser. To overcome this, VOCA expressly prohibited the denial of compensation to any victim because of that victim's familial relationship to the offender or because of the sharing of a residence by the victim and the offender. Even with this language, DV survivors are one of the most underrepresented groups receiving CVC funds. In her law review article, Professor Najere Rutledge argues how CVC funds should be seen as moral obligations from society to crime victims in order to help make them whole, rather than charitable gifts from the government. That way, CVC funds can be forced to be distributed to assist victims, rather than be withheld or given out by the government as they wish. She also argues against CVC requirements that do not advance the primary goal of victim assistance, such as cooperation with law enforcement, not having a criminal record, or negative social history, as this can leave many survivors without this necessary assistance. Next, communities have started restorative justice programs as alternatives to incarceration. Citing Blacklaw's dictionary, restorative justice focuses on repairing the harm done, meeting the victim's needs, and holding the offender responsible for his or her action. There are 3 forms of commonly used restorative justice programs for DV victims. First, victim offender mediation. That involves a face-to-face meeting between a victim and an offender in the presence of a trained mediator. The primary purpose is to create dialogue that can improve the victim-offender relationship and provide an opportunity for victim empowerment by permitting them to contribute the corrective measures taken towards the offender. Next, family group conferencing involves a trained facilitator guiding dialogue among family members, friends, justice officials, and service providers. Lastly, peacemaking circles are derived from practices used by Indigenous cultures in Canada, US, and Maori people. They facilitate dialogue among the victim offender and members of the community. While it is difficult to measure the effectiveness of these programs because of the difficulty in finding a universal measure of success, the Center for Court Innovation did a study of 65 different restorative justice programs in the country, and were able to find 8 different takeaways, with some of the most impactful being the ability to prioritize survivor agency and safety, having active accountability, and addressing diverse participant needs such as housing, medical, substance abuse, mental health training, and employment and counseling. I want to thank you if you've come this far and hope you learned about more effective ways to help survivors of domestic and gendered violence. As a past survivor myself, this project is extremely close to my heart as I've seen firsthand how ineffective resources can do more harm than good. If you'd like to learn more, I provided a link of resources for those looking for assistance if they are experiencing a crisis or interested in helping.